read that I cannot imagine no society which does not embody some method of arbitration. I convey my heartfelt greetings to everyone in attendance. I, Sudeep Chandra, a third year law student and student ambassador at LEDX EduTech and Project L1, I have honor of being moderator of today's session. I would like to welcome you all to our 2-day online bootcamp on arbitration law organized by LEDX. A warm thank you to everyone who has joined us today evening. I feel privileged to introduce our today's guest speaker, Mr. Alok Vajpayee sir, Associate at Khaitan & Co. Mumbai. Sir, thank you so much to be here with us today. We welcome you, sir. I would also like to acknowledge all the participants who have gathered here from different law schools for today's session. We welcome you all. Further, before starting the session, I would like to introduce our guest speaker to all, Mr. Alok Vajpayee. He is an associate working with the dispute resolution team at Khaitan & Co. Mumbai. Mr. Vajpayee has graduated from Institute of Law, Nirma University in 2018. His core practice areas are commercial arbitration, litigation under Arbitration and Conciliation Act, general commercial litigation before National Company Law Tribunal, and shareholders' disputes. He had also been advised in matters relating to Foreign Exchange Management Act, and he is also a qualified tribunal secretary certified by Hong Kong International Arbitration Center. Before starting the session, I would request all the participants to put up the questions you want to ask during the session in the chat box. Now, I would request our guest speaker, Mr. Alok Vajpayee sir, to start the session on the topic prospects of international career in arbitration. Over
Sure.
to you, sir.
Yeah. Thanks, Sudeep, for the kind introduction, and thanks to the team at LEDX for inviting me for this session. Uh, First thing first, just to tell a bit more about what I've done in terms of arbitration. And before I go into the question answer session, and I believe Sudeep, you want to question all the questions what the panelists have, or you want me to start on a basic note? Uh,
Sir, first you please start on the basic note. After that, I will taking some question and answer, which
Fair
we have
enough.
prepared.
So there were
Yeah.
some initial questions which were there in the introductory poster. You want me to start with those, or you would take those questions?
So I will talk this question, sir.
Fair enough. Okay. So yeah.
How
Uh,
to shape how to shape career as an international arbitration lawyer, and what are the future prospects as an international arbitrator?
Fair enough. So before I take this question, as I said, I'll be briefly telling about in the span of 4 years what I have done and how all or any of the law students who are watching this session can try and make mark in arbitration law. Now, I graduated in April 2018. Now, prior to graduation, right from my third year, I had an interest towards the subject. I did one moot, that is National Law School International Arbitration Trilegal Moot, that is organized by NLSIU Bangalore. And from that very uh, moot, as in the preparation of the moot took 5 to 6 months. And from that very moment, I started liking the subject. Now, with time in my college, I saw a comment from Parishi Gupta. She's saying my voice is breaking. Sudeep, my voice is clear, or it's only
Yes, yes,
Well,
you are clear now.
I think there would be a network issue because I'm able to
fair enough? Fair
hear.
enough. Okay, so right after this moot, I was pretty sure that I want to start working more on arbitration. So I planned all my internships in arbitration. in whatever remaining 3, 4 internships were. And when I graduated, uh, and when I sat in any of the interviews, I gave 2 or 3 interviews only. I made very clear that part of my practice should have arbitration. Now, the reason for liking the subject are numerous, uh, specifically being the different types of law which in a dispute can apply. So at a time you can do a matter where Singapore law is applicable, Indian law is applicable, and English law is applicable. And the amount of complexity you get is quite nuanced, which in any other law you don't get. So that was my major reason. And another big reason was, and this every law student should note, is with time the relevance of a subject matter increases. For example, in 2016, insolvency and bankruptcy code came. Now, I remember in 2018, uh, pass out people, most of the recruitments happen on the basis of the knowledge of insolvency and bankruptcy code. So, whenever you are graduating, or as a lawyer also, you need to understand what's the demand of the market at that time. At that time, when I graduated, apart from IBC, I also saw that arbitration was increasing and there was a demand in the market. It had a promising future as well. And considering all these aspects, I decided I want to do arbitration. Now, my stint at Singhania and Company, I did both domestic and international arbitration. In fact, my first case which I did after graduating was international arbitration and a pharmaceutical related dispute, which still remains one of the best matters I've done in international arbitration. So eventually, when I came at Khaitan, of course, arbitration was there, but I explored more. I did shareholders dispute, I did white collar crime, and now I'm doing almost everything in the ambit of disputes. But reasonably, I've done arbitration as well. Still, you see, after the span of almost 4 years, uh, like in any other subject, there's immense to learn in arbitration because the arbitration is as a subject would you would see that there's culmination of practices both from common and civil law. So whatever IBA guidelines are there, they have taken some aspect from the common law, some aspect from the civil law, and which and specifically if I talk about international arbitration, even in the institutional rules, the way and mostly it's quite flexible as compared to litigation. Ananya must have talked in yesterday talk about the difference between litigation and arbitration and how arbitration is more flexible. So, considering all these aspects, I decided to go for arbitration. And today I stand here with a bit of experience, but as I said, there's a lot to learn. I'm still at starting off my career, and hopefully, in whatever next talk I take, I'll give more than today what I'm giving. So, Sudeep, we can start with the questions.
So the first question we have: how to shape career as an international arbitration lawyer, and what are the future prospects as an international arbitrator?
Okay. Uh, so, considering that most of you are law students, uh, very first thing which remains is making your presence felt. Now, you see, when I graduated in 2018, I saw a lot of my seniors, juniors, and till today, I see that everybody wants to do arbitration. And it's not only about law students. You go in law firms, a lot of partners want to do arbitration. So the general trend, specifically when I graduated, that was at a peak, as in 2019, 2020. Everybody wants to do arbitration. Now, if that is the scenario, the question which as a student you should ask yourself is how different or how different you are from others. How you can make your presence feel which is which others are not doing. And how you can do so is of course doing moots. uh, writing papers on the subject matter, uh, putting comments on different aspect or new judgments which are coming upon, and making a network for yourself through LinkedIn or other conferences. So, as a student, these are 4 or 5 things which you should do definitely. As do different courses as well. Try and join some net, as in these uh, chapters which these institutions have. Let's say Young MCIA, Young ICA, and then there's mentorship programs also organized by Young ITA or Young ITA. So consider doing all of these things. Tell your experience. Look, in today's world, uh, one thing is very different, that you know a lot of things, but you have to show to the world also that you know all of these things. And how would you showcase that? You would showcase that by putting on LinkedIn that you have written this article, or maybe writing a comment on a new judgment and putting on LinkedIn, right? uh, okay, Shashwat has written a question. Sir, in these tough times, how do we land an internship in a reputed firm like Khaitan and Co, that too being a non-NLU student? Okay. uh, So I'll take this question for the time being. I'll try and answer it briefly. Look, tier one internship, irrespective of pandemic times or otherwise, also it's little tricky. It's little tough because everybody wants to do tier one internship. And specifically, my experience with Khaitan is there's no real difference between NLU or non-NLU people. If you are good at merits, you apply in time, you apply through a reference. Maybe you know someone who's working at Khaitan who has seen your work, and who can recommend your name to the HR. That would really help you, because stand understand from the perspective of the HR also. They receive no less than 50 to 60 application on average per day, and it becomes a task to really open and see and evaluate all of these. So uh, whenever you apply to any tier one firm, be it Khaitan or Cyril Amarchand, make sure you have a reference and not just a name reference. You should have worked for that person so that he can accordingly pitch for you. So that's one advice I'll give it to you. That, because that would at least secure you a internship interview at max. Uh, then it's upon you how you perform in that interview, whether you secure that internship or not. But at least to the interview level, he can pitch you. So he or she, whatever it is. So that's one thing. Another, there are a couple of more questions. Doing LLM in arbitration from abroad is more beneficial or from India only? I think it's a uh, why. Well, it's a question which a lot of students have, and it's a related question that whether we should do LLM right after our LLB, or we should wait for some time to get experience. And it's a related question whether we should do in India or out of India. Look, different people have different viewpoints on this. My viewpoint is very clear. You do LLM for 2 reasons. You do it A, for knowledge sake, and if you are doing for that reason, then you are entering into academia. If you are doing for knowledge sake, tomorrow you wanna uh, go and be a lecturer or do PhD or do something of that sort of. Or the second reason, you do it for knowledge. Apart from knowledge, you do it for network also. Now, if that is your reason, and that's my reason, if tomorrow I'll go for an LLM, I'll do from a dual perspective. One, of course, knowledge is there. Second is building your network. Now, in that 1 year, I'll make sure that whatever batchmates I have, first I'll make sure I do an LLM where there's a diverse background people, or someone from England, someone from UK. So those LLM which has renowned uh, view, or which are quite renowned. Now, once you do that, in the span of 1 year, you have to make good relations so that tomorrow, if a matter comes to them, they refer you. Now, be it your independent practice or be it you work in a law firm, at the end of the day, as a lawyer, it depends on your network, as in how many matters you can bring to the firm, how many clients you can bring to the firm, and how that will happen. That will only happen through your network and through your connections which you make in your LLM, because that's an opportunity for you to build relationship from people with different backgrounds, and then accordingly. So just imagine a situation: you are studying with someone who's from England, and you have a matter which has jurisdiction of England courts. So you would obviously try and approach that guy. Similarly, you should build a repo that if there's an Indian matter, that guy should approach you. And accordingly, you'll bring more matter to the firm or to yourself if you are practicing independently. So, in my opinion, strictly in my opinion, LLM should be done abroad, and it should be renowned LLM, maybe mid, which is one of the top LLM in dispute resolution. So, that's my take on this. Uh, Moving to the next question: what activities should the law student undertake? Oh, that question went away. Yeah,
There is another question from Siddharth Sukla. What activities should the law student undertake to make sure the CV looks specialized in the field of ADR?
I think I have answered this. Uh, Moot court competition relating to arbitration, blogs, both international and domestic, write blog posts relating to arbitration, write journals, case comments relating to arbitration, attend conferences relating to arbitration. Uh, you identify people who are doing well in arbitration, interact with them, make network with them, write comments on their post, on their uh, different articles, uh, and anything and everything relating to arbitration you should be aware of. So let's say when I graduated 2019, there was some reforms in Japan arbitration law. Nobody knew, nobody cared about Japan arbitration law. But Japan arbitration law has a three-tier regime, which is something quite different. And since look, that's how you build yourself or your presence felt in a meeting or so. A lot of people were discussing about Indian arbitration law and how it can be improved and how 2019 amendments have dealt with it. And then, as a speaker, you stand and you say that India can do something like Japan. Japan has done this, that. Then people automatically would think that this person knows a lot about arbitration. Not only India, apart from India as well. So, whatever opportunities you get in terms of conferences, be it virtual or physical, you try and make your mark felt. And therefore, as a student, you can do all these things. Maybe doing a negotiation, mediation competition, because the question was relating to ADR. Uh, Mediation bill is coming up. Uh, Sorry, mediation act may come up in future. So you may give your comments on the bill. You may participate on different sessions related to mediation law. So that's the way you can go about it. Uh,
So there is another question from Avnesh Kumar Sahu. What are the challenges for establishing an arbitration institution and pitching it to companies?
okay. So this question, I'll give you our answer through an example. So in 2016, uh, in India, a drive for institution arbitration started. Mumbai Center of International Arbitration uh, was opened up with the intent to do disputes relating to arbitration. Right now, as an institution, what's the first thing you have to do? You have to pitch to the companies, as he rightly said. While pitching, what you have to show to the company: A, you have a good track record, which a new institution might not be able to do. But a general institution, let's say SIAC, who has a good track record, would pitch to a company stating that, look, we have done 1,000 cases in this year and 950 has been enforced, this and that. That's number one, showing good track record. Second, showing that you have good facilities. You have good rooms, you have good video conferencing facilities, audio conferencing, transcription facility, uh, and you have good executive committee as well, who would be advising you on the rules, nuances of developments on arbitration. So let's say emergency arbitration provision should be there, early dismissal provision should be there, or early determination provisions should be there. So something of that sort of, to show that your institution rules covers everything. Third is something that you have experienced registrar as well, who has done a lot of arbitration. Now, experience court also you can say, because lot of it, let's say emergency arbitration is to be done, the emergency arbitrator has to be appointed by the court. So that's another thing. Fourth is you can show that you have something more than other institutions to offer. For example, ICC has a provision to scrutinize each and every award through the internal uh, review. Another thing is you can provide tribunal secretary or case management help, which would be beneficial for the parties as well as for the tribunal. And there are so many other related factors through which you can pitch your institution. Uh, that's all I think on this question. Next
Yeah,
question,
we
Kuldeep.
will move to the another question. There is another question from Himani.
Mhm.
How to start from basics into the journey of arbitration? What are the requirements, qualification, and how to proceed?
Okay. Uh, so can you open that question? I want to just requirement, qualification. Okay, fair enough. So I'll say that how to start is very simple. Read anything and everything related to arbitration. First, pick up a book, a good book. I would advise that. I started with Gary Bond, just because Gary Bond is the known personality in arbitration, the authority in arbitration. So the three-volume commentary, which was kept in my law school library, and it's available on Kluwer Arbitration as well, soft copy. If anybody wants, I can give that. So you start with that. Initially, you will feel very complicated. What is happening? What is not? But start from chapter one. Uh, there are some good chapters also. I think one is relating to applicable rules in international commercial arbitration. Read that. That's very important. Uh, and once you understand the international arbitration regime, then it's very, very important to understand domestic arbitration regime. Because after you graduate, mostly you will be doing domestic arbitration. That's the reality. Indians may few law firms, leaving few law firms or few advocates, mostly people do domestic arbitration. That's the large chunk. Specifically, the biggest litigator in India being government of India. So you need to understand how to deal with PSU related arbitrations as well. Now to understand, so now you have started with Gary Bond, you have read about international commercial arbitration. Then because ancestral model law is the basic model law on which the Indian Arbitration Act is based, you need to, but it's, there are a lot of developments in the Indian arbitration law for which you need to read the judgments as well. So understanding the Indian regime through judgments is very important. It will take more efforts than understanding the international regime. Specific wise, understanding any country regime would be a little tough because there you will be going specifics. How this court has interpreted this provision in their law. Uh, how, so for example, Singapore has two acts, Japan has three regimes, India has two regimes. As in, when I say regimes, it means international arbitration के लिए there are other provisions. And for foreign awards, there are other provisions. For domestic award, there are other provisions. So you have to understand how all of this operates so that you can understand. Coming to the questions of requirements or qualification, look, there's no qualification requirement, to be very honest. BLLB or whatever LLB you have done, that's enough to be a lawyer and nothing else. If you want to practice outside India, then maybe you need a license. Maybe you can take QLTS if you want a England and Wales license. But apart from that, I don't think any specific requirements are there to start with. Like people take this NCIAB or CIAB affiliation and all to show that they have interest towards the subject. That's fine, but that's not a requirement. That's not a necessity. Uh, if you have money, you can pay, then good for it. I think, and how to proceed, I've already answered. So I think that answers your question.
So there is another question. How can I work on international commercial arbitration matters in Singapore, Dubai, the US, London, and other regions? And what is different about international commercial arbitrations?
Okay. So uh, I'll tell you both in terms of the Indian Act as well as from the point of view of Gary Vaughan. Indian Act Section 21E defines an international commercial arbitration would involve one foreign element. It may be a party is based out of foreign, a company is based out of foreign, the subject matter is foreign. So there has to be one foreign element and it becomes international commercial arbitration, irrespective of the fact that part one of the act, which is relating to domestic arbitration, it applies. Now, what Gary Bond says. Gary Bond says when the seat of arbitration is different than the place where the parties are, then it becomes international arbitration. Now, the concept of seat is again a seat is referred to as a juridical home of an arbitration. What I mean by juridical home, I try and summarize this by two or three lines. No arbitration can function independently. You need courts to supervise that arbitration. Why it cannot function independently? Because unlike courts in any country which has backing of a statute, arbitrations might have a backing of a statute in terms of existing of an arbitration agreement or different powers to an arbitrator. However, unlike courts, there is no full-fledged procedure laid down in terms of what an arbitrator can do. And therefore, you need judges or a court interference to supervise that arbitration. Let's say parties are unable to decide the choice of arbitration. Then, where to go? Seat law. Parties are unable to take call on terms of who would, let's say there's a challenge with regards to the independence and impartiality of the arbitrator. Where to go? The court of seat law. So hence for supervisory purpose, you need a court, and how that court would be determined is through the choice of seat. So once there's a different seat from where you are staying, then it becomes international arbitration. So I think now coming to the second part of the question, how you wanna do matters in Singapore, Dubai, and all of that stuff. Look, if you are specifically very clear, you want to do a jurisdiction related matter, so you better practice in that jurisdiction. Practicing in India and making sure you only do Singapore related matter, Dubai related matter, it's not. It's sometimes it's based on your luck also. The team where which you are working with, उनको किस तरीके के matters मिलते हैं. Uh, so let's say if you wanna work in Dubai related arbitration, you better join a Dubai firm or you be an in-house counsel of a Dubai firm and pitch to them that I want to do arbitrations as well. And that's the only thing which I can think of in terms of jurisdiction specific practices. Let's say you want to do arbitration in Singapore, go to Singapore, take their license, join a law firm in Singapore, and practice. Look, in my last internship, I worked on Singapore arbitration law. The reason for the same is the person whom I was working with was an arbitrator, and the seat was Singapore. So he had a lot of questions with regard to कि Singaporean law में ये कैसे करना है, वो कैसे करना है, and so on and so forth. And therefore, I got to work on the Singapore law, and that was purely based on luck. So you can't really plan out that how I want to do for Dubai or Singapore. Maybe you can plan out by stating that you know the Dubai law well or Singapore law well and building your presence felt. And tomorrow, some client comes to you that considering your expertise in Dubai arbitration, I want you to take this matter. Then it's a different story. But directly at such junior level, I don't think you can do anything.
Sir, there is a question from Nuba Israt. Do we have career in arbitration law in abroad?
Of course, there are so many people who are working from India in different international law firms. Why won't you have? So, understand why a foreign law firm would hire you. Let's say you are the recruiter in White and Case LLP. Why would they hire you? The basic and major reason is your knowledge of Indian law. Now, there are a lot of Indian companies who are venturing out of India. They are working out of India. If they have a dispute in India where the seat of law is India, then where they would approach, and they would need a lawyer who knows Indian law, because in India, there's still no open access to foreign law firms. So how they practice in India is by involving Indian lawyers or getting in different collaboration with different Indian law firms. So your expertise of Indian law would help you in gathering a, let's say, a job offer from foreign law firm. That's one thing. That's one way of looking at it. Second is you go and do your LLB, LLM, everything from abroad, even LLM just abroad, and you build your expertise in their arbitration law. Then also that company can hire you or the law firm can hire you. Third is you work in an arbitral institution. My senior worked with CTAC, which is in China, and how these arbitral institutions work is because how he was hired. He was the only person in CTAC who knew English. Now CTAC wanted to build, because CTAC was an institution where there were majorly Chinese companies which are coming in. They wanted to expand it to English uh, speaking countries as well, and therefore they wanted someone who knew English, and therefore he was hired for his knowledge on both Chinese and English law. So knowing different languages might also help you in securing a career in international law firm. In any institution, you there are a lot of things to do. Managing a case, or uh, deciding whether that particular institution has that jurisdiction for that matter or not. So there are n number of things which an institution is involved in terms of administering the arbitration, and therefore there are lot of job openings in arbitral institutions as well. So that's another option you can do. But definitely, there's a career in international arbitration law. In fact, a very good career.
Sir, there is another question from Kashish Jaiswal. Uh, that means you are saying LLM from abroad will give you better jobs. For this, he has asked one question, sir, and says replying on that only. That
Okay,
be doing.
to answer that question, uh, look, in today's scenario, you see a lot of people doing foreign LLMs in arbitration. So there is a competition for sure. However, why the percentage reduces when it comes to job recruitment for people working outside India is because you need to understand the market. Today, England is at the, as in, the market has exhausted. Why you see Queen's councils coming to India and promoting themselves is very simple, because their market has exhausted. Now, tomorrow you do and go and LLM in Queen's Mary, then it's a very bad decision, because they themselves are struggling to give work to their people. How would you get a job there then? And then you would come back to India and say foreign law firm doesn't. Look, a blank statement like these should not be taken on consideration. There are a lot of things, lot of strategies which you should adopt while making any decision, be it doing a foreign LLM. You have to take different parameters. किस jurisdiction में cases बढ़ रहे हैं, किस jurisdiction में past में लोगों के employments लगे हैं, किस jurisdiction में Indian related matters बढ़ रहे हैं. When you analyze all these things, then there is a chance that you might get a job. Otherwise, it's not that easy. And then you also have to practice their clear their license also to practice. A lot of people have New York bar examination they clear the bar examination, and accordingly they practice. So it's not that easy. It's not that ki bhai foreign LLM kar liya and mil gayi job. No, it's one of the requirements, and that too a very good LLM, not like any university. That's my answer to the question.
Okay, sir. Further, we'll move to Tejaswini Kaushal. Is doing PhD after LLM improves one's chance of getting more highly paid jobs or research jobs? Is the capital investment in PhD worth the returns in law?
Is doing PhD after LLM improve one chance of getting more highly paid jobs? Uh, Look, if the capital investment in PhD worth the returns in law, it largely depends upon what's your capital investment. If you are doing a PhD in foreign, of course, it would be huge. And I really doubt, because once you are doing PhD, unless you are doing while practicing also, so then that's a very beneficial thing. So White and Case, because there's a partner known as with the name Matthew Seacom. He was doing his PhD on the topic uh, interest rate in international commercial arbitration. Now, if you are doing from that viewpoint, because there are a lot of law firm partners, principal associates who are doing PhD parallelly. If that is your way, then good. But if you are doing only for the academic purpose, as in you completed your LLB, then you did LLM, and then straight away PhD, unless you become really good or renowned professor, equivalent to Toby Landau or Gary Bond, I don't see a very good return on investment. You have to be lucky to be. I'll be very blunt on this. You have to be very lucky. Just doing PhD won't help you. There would be so many related factors uh, in order to really get return on investment. Because PhD would take easily, if you are doing residential PhD. Otherwise, if you are doing it remote wise, then it's still fine. But residential PhD would involve a lot of money. And utta return milna, I can't say. It depends on a lot
So
of factors.
further moving to another question. How to fetch internship in arbitration and which firm we can target? Shraddha Mathur.
Okay, so the first part of the question, how to fetch internships in arbitration, is very related to the answer which I give, how to embark your journey in arbitration. So once you are writing in arbitration, once you are doing moots in arbitration, because let's say you do one moot in arbitration, so you will interact with so many judges there who are actually doing arbitration, who are working in different law firms. So unse you can build your repo. Let's say you are I was the semi-finalist in NLSTM, as in the first moot which I did. So a lot of judges liked me in the preliminary round. A lot of judges said, or I approached them, I want to intern at your place. They said, of course, you apply, we'll give you the internship. And therefore, you built a network and through which you can secure internship. You write about arbitration, you interact with different people, and this is how you can secure arbitration internships. What was the second part of the question? And which, yeah, important, which firms we can target. So in India, there are very few firms which do international arbitration. Uh, so you can target Shardul Amarchand, you can target Khaitan, that too team specific, but some things are not in your hand. As in, you can't be too specific. Better word is beggars are not choosers. So if you are applying it Khaitan, you can't say, I want to work under this partner, I want to do these matters. No, you can't really do that. So, in general, stricto sensu, if you really want to identify which team you and if that is your, if you have that option, let's say an HR approaches you and say, Acha, which law firm partner you want to work with, then of course you can identify by just looking on the LinkedIn profiles of different partners. Sam has good arbitration team led by Rishabh Gupta, who does a lot of investment treaty arbitrations as well. Khaitan also does a lot of arbitrations. Cyril Amachand does a lot of arbitration. Uh, then Trilegal also has arbitration. Then Singularity Legal, uh, it's a niche practice area firm, but they also have a lot of arbitration. Lex Arbitry has a lot of domestic arbitration. Uh, DSK also has arbitrations. So right now there are a lot of firms doing arbitrations. Not that it's limited to few. It's just about the caseload. AZB has arbitrations. Good disputes team. Rajen leads it. So yeah, you can accordingly see and apply. But these are the 7 to 8 names which come to my mind in terms of law firms practicing or having a lot of arbitration matters.
So another question from Mahima: is there are government jobs as well for arbitrators? What is the scope of ADR in government sector in India?
As I said, government is the biggest litigator in India. But you need to understand how the arbitrators are chosen. Uh, the unilateral arbitration clauses are not now allowed in India. So it's not like which used to happen earlier. The Indian government PSU they chose one arbitrator, which is their past employee, and he's arbitrating the dispute. It doesn't happen that way now. So unless there's a sector specific judgment, then it's a different story. So how the arbitrators are chosen? A, through the consent of the parties. It can be through different ways. The the government PSU gives you a panel. That panel might have your name, but just having your name in that panel won't secure you an arbitration appointment. So arbitration jobs as such a concept is little heavy to digest. However, you can build yourself, pitch yourself in terms of making your mark as an arbitrator and do different arbitrations. The more arbitrations you do, the more people would approach you. You can build a sector specific expertise. Like, let's say you know construction law well, you know insurance law well, or you know uh, shipping law well, maritime law well. Then in maritime arbitration or in uh, construction arbitration, people might approach you to become the arbitrator. But there's no concept as in nothing can secure you or can say ki you would get that you are the arbitrator and you we will monthly pay you 500 or $1,000. Nothing of that sort of. You have to secure appointment and parties would directly pay you. So there's no concept of government arbitrator per se. That's
So
all.
what are the qualification and skill difference between an arbitration and mediation lawyer?
Yeah, that's a good question. So, to understand the difference between the skills for an arbitration and mediation lawyer, you need to identify that what are these process or what these processes are tending to achieve. Now, in an arbitration, a third person would adjudicate your dispute. Now, for adjudication, what you need to know the evidence. You need to balance the evidence. You need to have the knowledge of the procedural law, as in whether the parties are fulfilling all the requirements of the procedural law. That's an arbitrator need to know. Then the arbitrator also need to know how to prevent guerrilla tactics. Now, by guerrilla tactics, I'm saying a party may be non-responsive, or a party may try and delay the arbitration or try and put different issues in the arbitration. As an arbitrator, you need to know what different approaches you can build upon to really make sure that the arbitration runs well. Now, unlike a mediation, a mediator has to reconcile interests of the competing parties, right? Which is quite different from an arbitrator. Arbitrator is just giving a decision. However, a mediator is reconciling the interest. For that, you need to have the skill and you should assist the parties in examining their interests and goals and identifying their interests and goals. That also requires a skill and what's their psychological build up, what actually they're looking for, and bringing them to that point. Then you need to have good negotiating skills as well. You need to understand how negotiation works, how different interests are to be kept, and all this as a mediator, and how you can really push for those interests in the mediation. So, unlike an arbitrator, your role as a mediator is quite interventionist. As an arbitrator, you are just merely observer to an extent, unless some guerrilla tactics are going on, then you need to interfere. But mediator, as compared to an arbitrator, is someone who has to give more indulgence, is someone who has to lead the process. So that's the major skill difference which I can think of.
So we have one more question from Saurya. Like arbitration, what are the other fields that a law students can look forward for?
Sure, you just Google. There are no less than 50, 60 laws under which a law student can build expertise upon. You see space law, you see aviation law, you see uh, so many niche practice area, real estate. Uh, in fact, if you just pick up any law firm ka website, you just open the law firm website and you see different teams: employment law, corporate law, M&A, private equity, uh, white collar crime. So many teams are there. That would give you different practice areas apart from ADR and whatever we are discussing today. But there's no limit in terms of what are the subject areas. There's immense uh, subject areas which you can look upon, and both India, international IPRs, and everything. So that's something which you can easily get on any law firm website just for the idea sake, and then you can slowly build upon it, as in depending upon what area you choose. Aviation law, space law, all these are very niche areas. You need to identify which are the lawyers which are working. Drone law bhi aaya hai, so how that might impact. Data privacy is another coming area, so that's another area where you can build upon. So there are so many areas, as in how much to talk about it. So I think that's something I will leave on your research because there's no end to it. It will easily take 20 minutes to tell and discuss all these. So yeah,
Another question from Parisi Gupta. I want to ask how to achieve a career in work in international human rights law.
who told you I'm an international human rights lawyer? Okay, so I don't think I'm rightly placed to answer this question. But what I understand from people, uh, one of my senior is working with United Nations Human Rights Commission, and in terms of his background, he did his law from my college as in Nirma. Then he did his LLM from NLSIU. He was quite active in human rights law, and the same approach as I told for ADI. He wrote a lot of papers. He organized a lot of conferences. He built network. Unlike it's a very niche area, international human rights law. And then he secured a foreign internship, and slowly and steadily he made a mark. And right now he's just traveling across the world. And his work is a bit confidential, which I can't share because he told me things which are very confidential, and a lot of things which he didn't tell me, stating that these are confidential. But he travels a lot. That's the good part of it. Whenever I see his profile picture, he's out of some different country. So yeah, it's good, but I really don't know because I'm not a human rights lawyer to really give you that roadmap how to reach that level. Whatever I knew about him, I told you. But I think that should be the basic approach. But unlike arbitration, human rights is a more niche area. Arbitration is still a lot of arbitrations are there. There's still places where there is a vacuum and people need arbitration lawyers. But human rights, way less. That's what I can think of. Because another reason is a lot of my batchmates also had interest in human rights. They did a lot of moots, and 3 or 4 moots. They wrote papers, but then they end up doing normal law firm jobs, corporate law, taxation, not really doing human rights, which they really wanted. So from these instances, I understand it's a bit tough as compared to arbitration. Still, you can try for it. I'm not discouraging you. If you are good at it, then of course you'll make your mark.
Sir, how can we work? Sorry, how can we work with the international arbitration institutions like International Chambers of Commerce, London Court of International Arbitrations, Singapore International Arbitration Center?
Very simple. There are a lot of time they open their internships for applying. Then there are openings for case managers or for deputy counsel in these arbitral institutions. So once you build up your CV with regards to having required expertise, having required experience, having required knowledge, then you can accordingly start applying. And nothing better than, so let's say if you have no internships in arbitration, you start with small places where there's a chance you might get internship, or a institution which has just opened up, where there's a chance not many people might apply. So accordingly, you have to play it around. Strategically, you have to see that where my chances are more, and look for references. If you know someone who is working with an arbitral institution, ask him, request him, approach him on LinkedIn, and say that I want to intern at this place. Or a lot of times I've seen students doing voluntary work, helping in or assisting in research, just to make a good network or just to show to the other person that they are really interested in arbitration. Now, down the line, let's say somebody approaches me and he or she shows that they have a lot of interest in arbitration by doing free voluntary work without anything in return. Down the line, I would understand when I need something or when I'm at the position of hiring someone, I would pitch them for the position. Uh, and therefore, for different people, different things work. It's upon you how you take forward. So that's my answer to it.
Sir, there is one more question from Brajesh Dubey. From where it should be fine to pursue a career in arbitration, India or abroad?
Uh, Come again, what was the question? From where it's better to.
From where it's better to pursue a career in arbitration in India or abroad?
Well, that's upon you what you want from life. Uh, Strictly from, how should I put it? So there are people who want to stay in India just because they want to stay near to their families. So if that is your consideration, then pursuing a career in India would be fine. However, if you want to travel the world and have good money, then go abroad and settle and have that expertise also, have that capacity also. Then you can do. I think both are fine. Yeah, if you are good lawyer in India also, of course, people keep India a little low in terms of living standards and all. And if you don't like bumpy roads, pollution, and Diwali mein thoda ajeeb hone lagta, whatever it is, if that is the scene, then go abroad. There you'll have good life. And from that perspective, it's better to have a career outside India.
So further moving to the last question of the session, what are the prospects for an international career with foreign law firms as an arbitration lawyer?
What are the prospects of.
For an international career with foreign law firms as an arbitration lawyer.
The prospects are really good, yeah. As I said in one of the answers, uh, that just understand from the perspective of a foreign law firm. Today, because sheer number of population, India after China and because of COVID and all, India would become hub for a lot of investment. And of course, a lot of people would have different view on this. And with time, India has seen a lot of investment which has come in. And therefore, you see a lot of disputes happening between Indian parties and foreign parties. If that is happening as a foreign law firm, where you are not allowed, as in India, you are not allowed to enter the Indian market, what you would do? You would hire Indian lawyers who know the Indian law. So that's number one. So your prospects would increase because you are an Indian. You know the law here in India. Not only from the arbitration law point of view, other point of view also in terms of execution यहाँ पे होना है. So how CPC में execution would work. What are the different ways you can approach the execution issues. So you have an award. A foreign client has an award in your favor, in his favor, and they want to enforce against an Indian party. What all strategic calls they can take in order to prevent the Indian party from reallocating their assets or from diminishing the value of their assets. All these calls are very important, which as an Indian lawyer you would be asked upon if you're working with a foreign law firm. And therefore, it's upon how you understand in which jurisdiction. So I remember one of my seniors specifically studying upon which are the two jurisdictions wherein the Indian disputes are happening the most. And accordingly, he decided his place of LLM. So you have to take or think out of the box in order to stand differently from others. Unless you do that, unless you walk an extra mile, you are still placed on the same situation where everybody is. If you are just listening to what I am saying, which other 37, 40 people are listening, then you will be similarly placed. However, if you are going home and doing something extra, uh, which I haven't told, something which is out of the box, then you will succeed as a lawyer, both as an arbitration or human rights lawyer or whatever lawyer you want to be. So that's my take on that question.
Thank you so much, sir. We will be moving further. Sorry, sir, we can't move further. Thank you, sir, for enlightening us with your presence and for your advice and assistance. You are responsive to the needs of law students and are willing to help in a feasible manner. Thank you so much, sir. I am sure we all have grasped a lot from this session. And thank you, everyone, for sparing and joining us here today evening. Thank you so much, sir. And there
Pleasure,
is one
Sudeep.
announcement.
Pleasure, Sudeep. Thank you to LEDX for inviting me. And I think thanks to all the students for being so interactive. One of the few sessions where I saw questions coming on all throughout. So thanks, guys, for listening me. Otherwise, I can't see you, and I was under the impression a lot of you must be sleeping and just attending it. But thankfully, many of you were listening. Some follow-up questions were there.
Also,
Glad
see,
that.
I would take a few minutes more. There
Sure,
are a few questions left. If you may allow, we can answer that too.
sure. Please.
So there's this one question that states difference between arbitration and conciliation.
Constellation.
Okay, so if I have to draw a, so first in arbitration, you see the arbitrator gives an adjudication which is stricto sensu like a judge in a court. Conciliation is something which comes in between mediation and arbitration. Conciliator has to uh, what do you call push for a settlement which would be enforceable under the Arbitration and Conciliation Act. Unlike mediation, conciliation is well regulated under the Arbitration and Conciliation Act because till today there's no mediation law in India. So mediation remains unregulated. Conciliation is regulated with certain procedures defined under Part 3 of the Arbitration and Conciliation Act. And the conciliator is not someone who would adjudicate. He has to push the party for a settlement. So there is, as in, so mediation would come at this level where there's no real involvement of mediator in decision making. However, conciliator would come at a little higher standard wherein he might propose certain settlement terms or certain settlement points. And finally, the arbitrator, where the decision making authority is the supreme. So that's how I'll put it. In terms of legal differences, I think this would be fine. Uh, just study part three, you'll understand conciliation, because, as I said, conciliation, that's the broad idea which I've given you. But to really go into depth, it would take certain half an hour or so to really understand how conciliation in India works. So I think that, for the time being, that would be fine, right?
Sure, sir. And
Thank you. Thank you everyone for sparing time and joining us here today. And don't forget to join tomorrow workshop given by Mr. Sumit Malik, editor and director of EBC on legal research and writing. Participants can register for the online session as soon as possible.
Sudeep, say my hi to Sumit sir. I
Sure,
worked
sir.
with I worked with him in Eastern Book Company. He's smart fellow.
okay, okay, sir. Surely we'll convey your message to him.
Yeah, yeah.
Also, I thank you all the participants for being part of this bootcamp on arbitration for past 2 days. We are sure that you have had fun as well as learned a lot during these sessions. We promise more such activities in the future for your benefit. If you want to enhance your prospects and knowledge in arbitration further, you may register for our certificate course on arbitrations that is starting from February 7th, 2022. And only for you, as you all have been a great audience, we are offering special discount on the course's price as well. I'll share a WhatsApp link to all of you. You may join the WhatsApp group and avail your coupons from that particular group itself. Thank you. Thank you, Alok sir, for sparing your precious time with us. It has been a great session.
Thank you, Siddharth.
Thank you, sir. Thank you, sir.
Yeah, thank you, everyone.